You've seen it in the movies, right? You have the right to an attorney. But what happens when a crime seems, well, minor? So minor that you're told you don't even need a lawyer. That's what we're digging into today. We're talking about this huge gap in our justice system where a tiny offense can lead to life-shattering consequences. And it all goes back to a single legal rule that's been stuck in time for over 40 years.
I know. It sounds a little over the top, but for millions of people, this isn't drama. It's reality. Imagine this. You're charged with some low-level crime, and the prosecutor offers you a deal that seems like a no-brainer. But what if that deal, that seemingly easy way out, ends up costing you, well, everything?
So, let's walk through how this usually goes down. You're facing a minor charge. I don't know, maybe shoplifting or something simple like that. The prosecutor comes to you with a quick exit ramp. Just plead guilty, pay a small fine, and you can walk away. No jail time. Phew, right? It feels like a massive relief. The whole thing is over. But then, months, maybe even years down the road, that so-called win comes roaring back to haunt you in a way you could have never, ever predicted.
And that brings us to the real question. What is the hidden price of a minor conviction? It's a price tag that almost never gets mentioned when you're standing there in a courtroom, often completely on your own.
And look, this isn't some rare one-off thing. It happens all the time. Our misdemeanor courts are just swamped. They're built for speed, for efficiency. So in that rush to clear the docket, you have hundreds of thousands of people every year pleading guilty, with no lawyer in sight to warn them about the invisible, long-term trap they're about to walk into.
So, you gotta be asking, how did we even get to this point? Well, the answer, believe it or not, comes down to one single Supreme Court decision from way back in 1979, a decision that basically created this massive loophole in the system.
Okay, so for about half a century, the right to a lawyer was on this incredible journey. It was constantly expanding. It started out just for some capital cases, the most serious stuff. Then came the landmark case Gideon v. Wainwright, which stretched it to cover all felonies. A few years later, in '72, it grew again to include any case where you might face jail time. It seemed like the trend was clear, but then, 1979, the music just stopped. The Supreme Court's decision in Scott v. Illinois put a full stop on that evolution.
And this case created what's now known as the actual incarceration rule. The name says it all, really. It's a super simple but incredibly powerful standard. The court basically said the Sixth Amendment right to a government-provided lawyer only gets triggered if a defendant is actually sentenced to do time. Not might be, but is. And the thinking behind it was mostly practical. Trying to keep court costs down and focus public defenders on the cases where someone's freedom was literally on the line.
So here's the bottom line, the absolute crucial takeaway. No jail time equals no constitutional right to a lawyer, period. It doesn't matter how devastating the other consequences might be. If you're not getting locked up, you're on your own.
Now, back in 1979, that rule might have made a certain kind of sense. But the world we live in today, it's a completely different place. And because of that, this old rule has created a new, much harsher reality for anyone who gets caught up in the system.
Two massive shifts, have completely changed the landscape since then. First, you have the rise of policing strategies like broken windows and zero tolerance, which led to this explosion in arrests for really minor stuff. And second, at the same time, lawmakers were busy creating this giant tangled web of hidden penalties, what the legal world calls collateral consequences, that get automatically triggered by almost any criminal conviction. And the numbers, they're just mind-boggling. Thanks to these new policing strategies, our courts are flooded with something like 10.5 million misdemeanor cases every single year. You can see how the system is just built for speed, for processing people, not necessarily for protecting their rights.
And this is what's really waiting for you on the other side of that supposedly simple guilty plea. And we're not talking about minor annoyances here. We're talking about life-altering stuff. You could be deported, ripped away from your family forever. You could be forced onto a sex offender registry for the rest of your life. It could mean you face way more prison time if you ever get in trouble again. It could mean losing your children, your professional license, your apartment, even your eligibility for public benefits.
Just look at this chart to see how dramatically things have changed. In 1979, the year Scott v. Illinois was decided, only 264 people were deported because of a criminal conviction. Fast forward to 2011, and that number exploded to over 216,000. It's just staggering. It shows how something that was once a pretty rare consequence has become a central and often devastating part of our justice system. So all of this new reality, it forces us to ask a really fundamental question. Does that old rule still make any sense? Is it fair? When the so-called side effects of a conviction are actually way worse than the official sentence, maybe it's time we rethink the whole idea of the right to a lawyer.
You see, the law has these two buckets: direct consequences, that's like the fine or probation, and collateral consequences, which is all that other stuff. But let's be real. Look at this. On one hand, you have a direct consequence, a $50 fine for petty theft. On the other hand, a potential collateral consequence, being deported and permanently separated from your family. I mean, which one sounds more serious to you? At a certain point, you have to ask if that distinction even means anything anymore.
And you know what? Even the Supreme Court gets this. They've actually said, in their own words, that for a lot of people, avoiding deportation is way more important than avoiding a jail sentence. It's a clear admission that the stakes of these collateral consequences can totally dwarf the official punishment.
And this idea started getting real traction in 2010 with a big case called Padilla versus Kentucky. The court ruled that any lawyer worth their salt has to tell their client about the risk of deportation. It was a huge deal because it started to tear down that artificial wall between the criminal case and the real-world consequences. The court was starting to see it all as one big penalty.
And this really gets to the heart of why the right to a lawyer is so important. There's this great analogy legal experts use. They call it the master key. Think about it. Without that key, without a lawyer, all your other rights, the presumption of innocence, the right to challenge evidence, they're all locked behind a door you can't open.
So all of this really boils down to one final, huge question for our entire justice system. What actually makes a case serious? How do we define that?
Because right now, the answer the system gives is incredibly simple and, as we've just seen, dangerously out of date. The law says a case is serious enough for a lawyer only if jail time is on the table. All those other life-destroying consequences, they just don't count.
Which leaves us with this final thought. If a so-called minor offense can lead to you being deported or losing your kids or being branded a sex offender for life, is it ever really minor at all? And if the answer is no, then shouldn't everyone have access to that master key, the right to a lawyer? It seems like a question our justice system really needs to answer.